So in this series, we're talking about what is a qualifying investor. So the previous series, we spoke about generally what is investment protection in the framework. So talking about bilateral investment treaties, talking about domestic legislation, talking about investment agreements. So in order to qualify as an investor, obviously the investor, the entity being either a juristic person, or as we would call it, a legal entity, or a natural person, must be a qualifying investor. So in order to qualify as an investor, you have to look at this particular treaty or domestic legislation being referred to. So in your legislation, if we talk about from a South African perspective, the Protection of Investment Act, or you're talking about from a Namibian perspective, or a Mozambican perspective, there would be a definition in the domestic legislation of who is a qualifying investor for purposes of being provided with protection under either that specific investment treaty or domestic legislation. So an investor could be anything from a shareholder to an investor that is specifically defined in that treaty. So what you normally get is it should be a member or a national of another contracting state. So what we mean by that is, in order to be protected as an investor, the state from where the investment flows. So if, for instance, the investment flow is from South Africa to Nigeria, the South African entity or natural person must be deemed as a national of South Africa. So under the domestic laws of South Africa, that entity must be deemed as a South African national. Now under the treaty then, or the specific investment agreement, that person will then be deemed as a qualifying investor in that particular jurisdiction. If you're not a qualifying investor, so in some instances there's been arguments about whether a control in a company, so this is more from a shareholder's perspective, where the shareholders are entitled to invoke certain investment protection regimes. So this has happened in Ghana, where a Greek national has alleged that the Ghanaian government has invoked certain measures against its investment in the mining industry, and it attempted to lodge, or did lodge, an exit arbitration against the Ghanaian government, and under that specific agreement, it provided for the exit provision. The exit tribunal ultimately held that there was no jurisdiction because it was not a qualifying investor. In this case, the company was a Ghanaian company incorporated in Ghana, and the investor that controlled the Ghanaian company was a Greek national. So looking at the interpretation of the exit convention and what is deemed as an investor, the investor did not qualify. So it's very important to ensure that when you want to invoke certain investment protection provisions within a treaty, you do qualify as an investor, because in most instances these are preliminary points that will be raised by host governments saying that yes, you trying to invoke certain substantive rights under an investment treaty or domestic legislation, but you do not qualify to be an investor. So the important point in this segment is you must make sure that in structuring your investment, that you do comply with requirements to be an investor under the specific treaty or domestic legislation you intend to rely on when the government imposes certain measures you deem as a violation of either treaty or domestic legislation.